So this is going to be the detailed video of Mental Hygiene Law, Article 10, which is sex offenders requiring civil management. So the first section is talking about the legislative findings and that recidivist sex offenders pose a danger to society that should be addressed through comprehensive programs of treatment and management. So basically these proceedings are meant to take someone who cannot be cured. And it says in extreme cases, confinement of the most dangerous offenders will need to be extended by civil process in order to provide them the treatment and to protect the public from their recidivist conduct. So again, this is talking essentially about people that cannot stop themselves. They are not able to be treated, cured. They've most likely served the maximum period of their sentence. Then it goes on to say that the system for responding to recidivist sex offenders with civil measures must be designed for treatment and protection. It should be based upon the most accurate scientific understanding available, including the use of validated risk assessment instruments. So again, this is another section where we're hearing the phrase risk assessment. It says, ideally, effective risk assessment should begin to occur prior to sentencing in the criminal process and should guide the process of civil commitment. We need information before you even sentence the person. So then G says, sex offenders in need of civil commitment are a different population from traditional mental health patients. So the article Dorothy's talking about, that is a different type of mental health patient. Okay. And then it says, accordingly, commitment of sex offenders should be implemented in ways that do not endanger, stigmatize, or divert needed treatment resources away from such traditional mental health patients. So the idea is in Article 9, the person can hopefully be treated after, months or years in a mental hospital. Whereas these people, they may have to just be put away to protect the public. So then it goes into the definitions, and the definition of designated felony is actually changing right before we take the test. Because of that, I'm not sure that it's so important to know this list of designated felonies, but just know maybe that designated felonies, they are not necessarily sex offenses. They're all things that can be done that have nothing to do with a sex offense. To 10.05, notice and case review. Most of this is in the other video, but just to give a detailed explanation of C says the notice to the Attorney General and the Commissioner of Mental Health, because that's who's getting the notice, to the extent possible, shall contain the following: person's name, alias, date of birth, sex, physical characteristics, anticipated future residence, photograph and set of fingerprints, criminal history, the acts constituting the sex offense, the most recent sentence, the pre-sentence report, other available materials concerning the sex offense, institutional history, records of parole, release, interviews. The commissioner shall be authorized to designate multidisciplinary staff, including clinical and other professional personnel, to provide a preliminary review of the need for detained sex offenders to be evaluated. So this is basically a team of people that's going to be compiled based on all these records, including the records and reports provided by the DA of the county where the person was convicted. In the case of a person determined to be incapacitated or not responsible by reason of mental disease or defect, the county where the person was charged. So the reason they're putting that in here is it's saying that you don't necessarily need to be convicted of anything. And as will further be explained when we get to the trial section and the issues of fact that the jury has to decide, someone who was found not fit to proceed will be included in this. Or can be included in this, I should say. E says, if the person is referred to a case review team for evaluation, notice of such referral shall be provided to the respondent. Okay. If the case review team finds the respondent is a sex offender requiring civil management, it shall so notify the respondent and the AG in writing. The first one, it's the notification goes to the Attorney General and the Commissioner of Mental Health. This notice here is going to the respondent and the Attorney General. The written notice must be accompanied by a written report from a psychiatric examiner that includes the finding as to whether the respondent has a mental abnormality. When the notice indicates that the person was convicted of a designated felony or charged with a designated felony, it shall also include the team's finding as to whether the act was sexually motivated. The case review team shall provide its written notice to the Attorney General and the respondent within 45 days of the Commissioner receiving the notice of anticipated relief. It's a very soft 45-day rule, as I explained in the other video. Another soft time rule here, it's a 30-day time rule. The Attorney General shall seek to file the petition within 30 days after receiving notice of the case review team's finding. Okay? Then within 10 days after the thing is filed, the respondent can try to move the venue, and the Attorney General then has 5 days to dispute the removal of the venue. Okay, so something to note in this section here is that it's talking about if the Attorney General wants the person to submit to an examination, a psychiatric examination, the court shall order it. And the psychiatric examiner is chosen by the Attorney General, not the court. And at that time, the court has to appoint counsel for the respondent. So then again, now it goes into if the respondent was supposed to be released or may be released prior to the time the review team makes a determination, and the Attorney General determines that the protection of public safety so requires, he may file the securing petition. Within 30 days after the petition is filed, so this is a regular petition, not the securing petition, or within such a longer period as he consents to, the respondent can consent to a longer period, the Supreme or County Court shall conduct a hearing without a jury to determine whether there's probable cause to believe that the respondent is a sex offender requiring civil management. So there's several things that are important here. Number one, the determination that the person is a sex offender requiring civil management is always going to be made by a judge, not a jury. It's always going to be made by a court. The issues of fact of whether or not someone is a detained sex offender with a mental abnormality, that issue is one of the issues that a jury will decide. Okay. So this, again, is if he's going to be released, it's no later than 72 hours unless they consent to more. And it's basically the same rules as a felony hearing, except the 72-hour rule is very, very soft. Can be respondent's consent, Attorney General shows good cause. It can be adjourned, and it shall not result in the dismissal if they do not do anything. So it doesn't result in the dismissal, and it doesn't result in a release. So that's different than in a felony hearing, which obviously the time rules in a felony hearing are different, but rules about release are very different.